What is a right to light? A right to light is a type of easement. The dominant land here is B, and it can restrict A, the servient land, from interfering with B's right to light. An easement is usually a dominant owner's right over servient land. A right to light is a negative easement and allows the dominant owner to restrict the use of the servient land if it would interfere with the light that goes over the servient land and into a building on the dominant land. Use in this context is any use that would interfere with the easement. A right to light is also referred to as an easement of light or ancient lights. Coles and Home and Colonial Stores Limited gave rise to the test to whether a right to light has been affected enough to need a remedy. Here, the building of a 42-foot high building across the street blocked the light to 2 of the 5 windows that had a right to light. The right to light was accepted by the court, as was the reduction in light due to the building. However, the court put forward the following test. If there is sufficient light according to the ordinary notions of mankind for the comfortable use and enjoyment of his house as a dwelling house, if it is a dwelling house, or for the beneficial use and occupation of the house, if it is a warehouse, a shop, or other place of business. Note here that there is a distinction between residential and commercial, which will be further discussed. However, this can be simplified to if the building has sufficient light for the ordinary use. This means not any interference needs a remedy. It may be more appropriate to call it a right to sufficient light. This is, however, a subjective test. In Allen and Greenwood, a right to light was claimed over a greenhouse. This is perfectly valid as the light only needs to go through a defined aperture, usually a window, of which a greenhouse has many. The court held the amount of sufficient light needed to be higher due to the ordinary use of the greenhouse. This shows the importance of the ordinary use and how subjective this test is. In Cars Sanders and Dick McNeil Associates Limited, the 50-50 rule was put forward. The 50-50 rule was an objective test. Here the court disfavoured its use due to its lack of consideration of what the ordinary use of that room is, and instead favoured the test put forward in Coles. If the court applied the objective test in Allen and Greenwood, there would not have been consideration for its ordinary use, and no remedy for the right. The Law Commission's Rights to Light Report, number 356. The Law Commission made many proposals for change, but the 2 changes of concern in this presentation are the use of prescription to acquire a right to light and the appropriateness of injunctions and damages. 2 further points for consideration which the Law Commission did consider are the distinction in remedies between commercial and residential, and the right to light for solar panels. Prescription. Prescription is the most common way a right to light is acquired, and it can happen in 3 different ways: by common law, by lost modern grant, or by statute. For common law, it would have had to happen since time immemorial. This is defined by statute as the 3rd of September 1189. But due to the difficulties in proving this, if it is enjoyed for 20 years, it is presumed that it has happened since time immemorial. This is defeated by proof that it has commenced since then. Occurrence by the lost modern grant is where 20 years of uninterrupted enjoyment of an easement will allow the law to adopt a legal fiction that a grant was in fact made. This is not affected by evidence that proves the contrary. By statute arrives from the Prescription Act 1832. Section 3 of the Prescription Act states, "Access and use of light for any dwelling house, workshop, or other building shall have been actually enjoyed for the full period of 20 years without interruption. The right shall be deemed absolute and indefeasible." This doesn't need to use a legal fiction or to presume its prior existence. If it has been enjoyed for 20 years, it creates a right. However, Section 4 allows construction of a physical obstruction of more than a year with notice to break this continual use. This is only if no action is taken by the dominant land. In lieu of a physical obstruction, Section 2, subsection 4A of the Rights of Light Act 1959 allows the registering of a local land charge that is as if an opaque structure was made, a theoretical obstruction. This allows for the right to be blocked without an actual structure. The Law Commission wants to abolish the free methods of prescription and replace the doctrine with a statute that allows for the prescriptive acquisition of easements. Although they say they are abolishing prescription, it seems more a consolidation and simplification of the law into one statute. Although making it simpler to administer, the changes set out would make it more difficult to acquire a right to light. It no longer sets a right to light out separate from other easements. This means that proof would be needed by the usual rule of easements of without force, without stealth, and without permission. These changes, if implemented, will undoubtedly decrease the amount of rights to light that arise. A consolidation is needed to simplify and reform the law of all easements, but a right to light should be treated differently to other easements, as it has been before. Its lack of express declaration that is not present with other easements is the reason for the shorter prescription time. If, for instance, the right to light is grouped in with the rest of easements, it would be more difficult to acquire rights to light, decreasing the amount of rights to light that do arise. Now to the question of injunction or damages. An injunction is an equitable remedy that allows the court to prevent or stop the development of a building, but most controversially, it can order the destruction of the development even when the development has been leased, as seen in H-Truck. In lieu of an injunction, damages can be awarded. Shelfer put forward that damages should be awarded instead of an injunction if the injury is small, is one which is capable of being estimated in money, is one which can be adequately compensated by a small money payment, and the case is one which it would be oppressive to the defendant to grant an injunction. Lord Neuberger, in Coventry and Lawrence, proposed that public policy and proportionality should be also considered. The guidelines in Shelfer have problems due to what constitutes a small injury or small money. Lord Neuberger's suggestion are a more modern approach, but these rules do need consolidating. The Law Commission's proposals do a good job of consolidating these rules and removing the ambiguity that is currently there. This reform would solve the current problems with the issue, but don't seem to get to the root of the problem. This leads on to my next point of distinction between residential and commercial. This distinction is based on the difference of enjoyment in commercial and residential properties, and how a right to light affects these. The commercial-residential distinction. This is not a call for complete separation of the doctrine. The distinction is only in respect of remedies. The acquiring of a right to light and the test for sufficient light would still stand unchanged. The reform would make commercial remedies damages, unless it would be unconscionable not to give an injunction, and residential remedies would be injunctions, unless it would be unconscionable to give one. The reason for this separation is due to the different types of enjoyment in land. Commercial enjoyment in land is primarily a financial one. Residential enjoyment is closer to the everyday meaning of enjoyment, and light undoubtedly forms a big part of this. Damages to a commercial body could go towards increased cost of lighting or installation of additional lighting if necessary. Damages to residential land are not adequate. It cannot buy happiness nor enjoyment of land. If you also consider that it is common practice for commercial buildings to have sufficient light from artificial lighting, regardless to the light from outside. This was considered in Midtown Limited and City of London Real Property Company Limited, where artificial lighting steered the court away from an injunction. The use of artificial light does cause problems with the question of sufficient light for ordinary use. If this is, however, proved, it would not be fair to issue an injunction, but damages would be. Protection of solar panels. Solar panels are another area that the Law Commission should have further considered. They themselves point out the problem with one part of the government giving financial aid to buy solar panels, and another not helping to protect the use of this commodity. Problems were raised with the issue of how this could be a defined channel, which if you think of a solar panel as a single panel that sun falls onto, makes sense. However, solar panels are a little more complex than that. In the diagram you can see that light passes through several window-like layers, like defined channels, until it reaches the photovoltaic cell. Calling this a defined channel is not a great extension of the law. A right to light in its nature is a negative easement, which the courts are understandably reluctant to extend. However, on the question on injunction or damages, Lord Neuberger suggests that public policy should be taken into consideration. Considering this, energy stability is definitely a public policy concern, which is why the government aids and rewards those who invest in solar panels. This would be a way of protecting the growth of renewable energy. If earlier considerations for reform are listened to, this would only be protected under residential claims, not commercial. This is because in commerce, solar panels are more of an investment that is considered at great length by professionals. In residential properties, this professional consideration is not given. It is usually following government reward schemes and for growth in renewable energy. A step in the right direction rather than an investment, although this is not to say that the reduction of bills is not considered by the residential property owners. To summarise the reforms, prescription should be consolidated into a single statute, but it should keep a right to light separate within this statute. Due to its lack of express grants given, not doing this would lead to a massive reduction in right to light protection. Next, introduce a remedial distinction between residential and commercial claims to help aid in certainty and allow for more appropriate remedies in relation to the enjoyment of land. Finally, the protection for those who buy solar panels following government schemes should be protected under a right to light. This is because the light is coming through a defined channel, and Lord Neuberger's consideration of public policy in a right to light allows for justification due to the need for energy stability and the movement towards more renewable energy. These changes would help certainty within all areas of a right to light, but will in particular allow for greater clarity and protection for residential land. This certainty would also allow for reduced costs in litigation for firms operating in this area.